Testimonial privileges. Federal courts recognize several testimonial privileges. There are no federal rules of evidence privilege rules. Federal courts have created and adopted these privileges. State privilege rules, which often vary, apply to federal cases based on diversity jurisdiction. Testimonial privileges are attorney-client, clergy-penant, spousal, marital communications, psychotherapist, social worker, and governmental. Self-incrimination. Under the Fifth Amendment, witness cannot be compelled to provide self-incriminating testimony in either civil or criminal cases. Witness may invoke privilege if there is a reasonable possibility of self-incrimination. Civil cases. Jury may draw an adverse inference from witness's assertion of the Fifth Amendment privilege. Criminal cases. Defendant cannot be punished for invoking privilege. Note, these privileges are not federal rules of evidence rules. The MBE usually assumes the existence of these privileges, but an answer choice indicating any of these privileges is an evidentiary rule will be incorrect. Attorney-client privilege. Communications between an attorney and client or client's representatives are privileged in all proceedings unless waived. Organizational client. Privilege applies to any employee authorized to speak to the attorney. To be protected, a communication must be intended to be confidential and made to facilitate legal services. Exceptions. Privileges does not apply to 1, crime or fraud. Privilege does not apply if the client seeks legal services to aid in the planning or commission of a fraud or crime. 2, attorney defending malpractice claim. Privilege does not apply if communication relates to an alleged breach of the attorney's duty. Joint representation of parties in a lawsuit. There's no privilege. Where an attorney acts for both parties in a transaction, no privilege can be invoked in a lawsuit between the parties. But privilege can be claimed in a suit between either or both of the parties or a third person. Fees not covered. Records of fee payments, including fee arrangements and payments, are generally considered outside or not covered by attorney-client privilege. Doctor-patient privilege and therapist-client privilege. Physician-patient privilege prevents disclosure of information confidentially conveyed by a patient to a physician. Statutory privilege is not recognized in the federal rules of evidence, but recognized and applied in most federal courts on the basis of state law. To be protected, communication must be 1, made for the purposes of obtaining diagnosis or treatment, 2, pertinent to diagnosis or treatment, and 3, intended by the patient to be confidential. 3, exceptions. Privilege does not apply where 1, patient's condition is a legal issue such as a personal injury, 2, physician services were sought to aid in a crime, tort, or to escape capture, or 3, dispute between doctor and patient such as malpractice. Psychotherapist or social worker patient privilege. Material conveyed by patient is privileged in all civil and criminal cases if 1, the client intends the communication to be confidential, and 2, communication is made to facilitate therapy or social work. In many ways, this privilege operates similar to attorney-client privilege. Spousal testimonial privilege. Criminal cases only. A person whose spouse is a defendant in a criminal case cannot be called as a witness by the prosecution or compelled to testify against his spouse in a criminal proceeding. Only the witness spouse may invoke the privilege. Defendant cannot prevent a willing spouse from testifying against her. Privilege can only be invoked during marriage. Marital communication privilege. Civil and criminal. Confidential communication made during marriages are privileged in any later proceeding. This applies if spouses divorce after confidential communication was made. Either spouse may invoke the privilege. A spouse can lose the privilege if he breaks confidentiality or relays a marital communication to a third party. The other spouse still retains the privilege. Exceptions where privilege does not apply are suits between spouses, suits in which one spouse is charged with a crime or a tort against the children, or suits in which spouses are co-defendants.